Okay, so we've just talked about the types of breaches, a fundamental breach and a simple breach. Now we're going to talk about the remedies in a bit more detail. And we'll start with a buyer's remedy for a seller breach. The seller has breached its obligation to deliver conforming goods. What are the remedies available to the buyer? Now the CISG in this case, again, we could set all of these out in the contract, but if they're not in the contract, we go to the contracting system, the CISG, and the CISG permits several different remedies. And in fact, these remedies can be stacked upon one another as long as we get to the point where it makes the aggrieved party, the non-breaching party, whole. The first remedy would be a right to performance, specific performance. And in the case of a sales contract, specific performance would mean making the seller sell you the goods, making the seller deliver the goods called for in the contract. There is a right to fix additional time. The seller and the buyer can agree on additional time in which the seller can deliver the goods, and the contract will stay in existence. The contract permits the parties to provide additional time for performance. In the case of a fundamental breach, there is a right of the buyer to what we call avoid the contract. This remedy is called avoidance. In the United States and common law systems, we call this rescission. But what rescission means essentially is that it is as if the contract had never existed. Meaning, if I avoid a contract in the event of a seller not selling me the goods, I can walk away and have no obligations to pay for the goods. The avoidance would terminate our obligations, and in fact, avoidance puts the parties back in the position they would have been in had the contract never occurred. So it's sort of an exception to the general rule. We'll talk a bit more about it. Price reduction. If the goods are non-conforming, but I as a buyer think I might have a use for them, I may be able to pay a lesser amount, the fair market value of the goods that I received, and retain them. Even though the seller didn't perform, even though the seller wants to send me the goods for the full price, I'm going to have a right to simply reduce the price that I'm going to pay for the goods that were delivered. And finally, a right to money damages. We're going to talk a lot about money damages in the next section of the course, so we're going to discuss this very briefly. But those are your different remedies available to a buyer in the event that the seller breaches. Now keep in mind, however, that a buyer has a duty to mitigate damages. And what that means is that a buyer has an obligation to minimize the damages that are going to happen because the seller breached. The buyer has certain obligations. The buyer has a responsibility to what we call cover. And cover means that the buyer has an obligation to go out and purchase substitute goods. In the event of a breach by the seller, the buyer cannot simply bide its time and eventually sue for the complete failure to sell the goods or to ship all the goods. Instead, the buyer has an obligation to minimize its damages by going out to purchase substitute goods, to purchase goods that are of the same type and quality as the goods the seller was supposed to deliver. And this is important because when there's a breach, the non-breaching party cannot simply sit back and watch its damages go up. Instead, the non-breaching party has an obligation to affirmatively act to reduce its damages. Let's talk about each remedy in a little bit more detail. The buyer's right to specific performance. Specific performance means do what was called for in the contract, meaning a seller must perform its contractual obligations. The seller must do what the contract called for. Now, ordinarily, specific performance is not available as a remedy. It's because the law much prefers money damages as opposed to performance damages. Sometimes we call these performance damages and non-performance damages. The law prefers non-performance. And in the case of specific performance, it's generally only available where the item is unique or where it may not be possible to cover. So in the event, say that a seller is going to sell you or promises to sell you a classic automobile, and maybe it's a classic Ferrari and there's only 15 of these cars in the world. Well, if the seller breaches and fails to sell you the goods, there's no other good that may be available to you. So therefore, there is no measure of what money would be required. The only thing that's going to make you whole is the seller being required to perform. So specific performance is a harsh remedy because ordinarily the law does not want a seller to have to sell goods when the seller doesn't want to sell those goods. Nevertheless, if the goods are unique to themselves, then specific performance may be available. Now, I say this remedy is subject to availability under domestic law because in the United States, in fact, in any common law system, there is a great reluctance on the part of courts to order specific performance. In a court based in the United States or an arbitration panel based in the United States, it's going to be much more difficult to obtain specific performance than it would be in a court or an arbitration panel based in a civil law country. In those civil law countries, which is most of the rest of the world, any area of the world that's not associated with the UK, the specific performance may be more readily available. Now, there's still a prejudice against its use. The law would still prefer monetary damages, but there is a much greater likelihood of obtaining specific performance in cases where it's going to be decided under a civil law system. Avoidance, we said, is that buyer's right to simply avoid a contract, to walk away from the contract. When a seller commits a fundamental breach, and again, for our purposes, that usually means a failure to ship, the buyer has the right to walk away. The buyer has no obligation to take those goods, to accept late delivery of those goods. Avoidance gives to a buyer a second chance. It's the right to walk away from the contract, to avoid the contract. And sometimes for a buyer, it may be advantageous to avoid the contract. In the case where the price of the goods has dropped from the time of the contract price may be much more than what the market price is. So in the event the seller failed to ship you the high-priced goods, you may simply choose to walk away and go buy the low-priced goods at the market price. So avoidance is a remedy that's available but not required to take. If there is a fundamental breach, the buyer simply declares the contract avoided. It's a remedy in which the parties walk away as if the contract had never existed. Buyer doesn't have any more obligations. The seller doesn't have any more obligations. The contract is rescinded. Price reduction. And again, I pointed out a buyer who would like to retain the goods, even though they may not be what was called for in the contract, may reduce the amount that's paid. Say you are a computer manufacturer and you have ordered hard drives for your computers, and you had ordered 500 gigabyte hard drives, and instead the supplier delivered 250 gigabyte hard drives. You as a manufacturer may have a use for those 250 gigabyte hard drives. Therefore, you may elect to keep those hard drives and pay a lesser amount. Maybe they cost less. You pay a lesser amount. So a buyer has a right, if the goods that were sent were not the goods that were called for in the contract, but the buyer may have a use for them, the buyer can pay the actual market price for the lower quality good or the lesser quality good. So a buyer has a right to price reduction. And that's another important remedy available to a buyer. Maybe you figure that the 250 gigabyte hard drives are plenty and you don't need the 500 gigabytes hard drives after all. Well, you're going to save yourself a lot of money by paying a reduced price. So what happens is the buyer simply withholds a part of the purchase price to offset the reduced value of the goods that were actually delivered, the non-conforming goods that were delivered. And finally, money damages. Again, we're going to spend a lot of time covering money damages, so we're not going to focus on it here, but understand that the general measure of damages is going to be the difference between contract price and market price. Get that idea in your head, because when we're discussing damages, that's really what we're going to be talking about. What's the difference between the price that was called for in the contract and the market price, the price that I had to, that I actually incurred?